A pre-trial hearing was held today in the Amber Spradlin case at the Pike County Judicial Center. Commonwealth's attorney Brent Turner spoke first, requesting that the December 1st trial date be postponed to allow for the completion of DNA evidence, explaining that there is very significant blood evidence and hairs found at the scene that still need to be tested. Turner told Judge Eddie Coleman they have about 70% of the evidence so far, and that it would be unfair to all involved to go to trial without all of the evidence.
In our position, Judge, is it's not fair to the Commonwealth to put us in a position where we have the entire burden of proof at a trial, to be forced to go to trial and try to present a complete case of all the evidence without all of the evidence. And we also believe that it's not fair to a jury to be put in that position. You've got, a young woman here that was brutally murdered, and she's dead in the ground, and she ain't coming back. And we got a guy sitting over here that's looking at the possibility of life in prison. And the jury's going to be under a lot of pressure to try to get that right. And I think it would be a disservice to the jury on a case of such consequence to ask them to make a decision when we have all of this evidence out there that's not even been done.
Hey, it's fall, y'all, and it's time to fall into some incredible savings with the region's best network, Appalachian Wireless. Shop the latest devices at prices you'll love and discover plans made just for you. Don't wait. Visit us online or stop by one of our many retail locations today, because we are you. We are Appalachian Wireless.
Defense attorney Stephen Romines was quite passionate in his rebuttal, stating that the Commonwealth has had plenty of time to test all of the evidence and that they have been setting the conditions to suit their needs. He also requested that M.K. McKinney's bond be reduced, claiming that the circumstances under which he is being detained are unconstitutional.
He says it wouldn't be fair to go to trial. It's not fair for someone who's never been charged with a crime to sit in jail for 2 and 3 years while they get their ducks in a row for a case that they brought. We've asserted a speedy trial claim. This is the 3rd time. That is in the Constitution. A right to a speedy and public trial is guaranteed by the 6th Amendment. A right to a reasonable bond is guaranteed by the 6th Amendment. And apparently the Commonwealth doesn't put much stock in those either.
After a 10-minute recess, Judge Coleman heard final comments and then announced that he will make a ruling in 2 days. Reporting for Mountaintop News, I'm Robin Tillman.